government came with NJAC, National Judicial Appointment Commission. Correct? So National Judicial Appointment Commission when came, तो क्या हुआ यहाँ पे? This National Judicial Commission will be consisting of Chief Justice of India, 2 senior Supreme Court judge, then 1 law minister and 2 eminent jurist. Understood this? So this National Judicial Appointment Commission is consisting of Chief Justice of India, 2 senior most judges of the Supreme Court, Law Minister of India, and then 2 eminent members. Okay, and these eminent members, they will be chosen by one committee. These eminent members, they will be by one select committee. This select committee will consist of Chief Justice of India, Prime Minister of India, and leader of opposition. This will be done leader of opposition in Lok Sabha. Correct? And these 2 eminent जो भी members होंगे, आप jurist की जगह member लिख लो अभी, better है, members. They will going to be appointed for how many years? 3 years के लिए only in this NJAC committee, and then they are not eligible for reappointment, and then not eligible for reappointment. ये क्यों बोला गया? Because so that they can work in free and fair manner. If अगर उनको लगता है कि they can be appointed again, then definitely they will going to support the government. So because of that, this restriction has been put over those 2 eminent members. These 2 eminent members will be selected by the CGI. He will be the chairperson of this committee. Another member is Prime Minister, another member is leader of opposition. अभी clear हो गया इतना? Done. So this NJAC came just to replace the collegium system. Correct है? Then this case actually came in Supreme Court. जिस केस को हम लोग बोलते हैं 4th judge case. 4th judge case. When this 99th constitutional amendment you are doing, actually it was related to the amendment of, it was related to the judiciary appointment of judges. So only parliament cannot amend it. We need to take support of the states also, half of the states. So this 99th constitutional amendment was enacted only after getting passed from the parliament with a special majority, and then half of the state also passed it. Then it came into existence. फिर क्या हुआ? Some of the individuals, they filed petitions before the Supreme Court regarding the constitutionality of this NJAC. Correct? Regarding the constitutionality of this NJAC, and this case is known as 4th judge case. Third तो already हो गया. This is 4th judge case. In this 4th judge case, Supreme Court says that this is basically a violation of basic structure of constitution. कैसे हो गया violation? Because it is violating independence of judiciary. I told you independent judiciary is the basic feature of the constitution. Now, how this independence of judiciary gets violated through this? They say that यहाँ पे one member is law minister and this person belong to the executive. Yes, Supreme Court. So Supreme Court rules that जो NJAC it is a violative of the basic structure of the constitution as it affects the independence of the judiciary. Done. So see, when this NJC was passed by parliament by special majority, then it is passed by half of the assemblies of the state. Iska matlab it is passed by the people of India only. And entire thing has been struck down by the Supreme Court just by saying that it is affecting the independence of the judiciary. The Supreme Court has again revived the old collegium system only. Understood? So current affair थोड़ा बढ़ गया था, बाकी तो कुछ नहीं हुआ, है ना? सो कंटेंट बढ़ गया है, बाकी इसका कोई यूज नहीं है अभी. एनजेसी इज नॉट अवेलेबल, इट इज नॉट एग्जिस्ट, इट इज स्ट्रक डाउन विद सुप्रीम कोर्ट. So Supreme Court has revived against the collegium system only. So before that, whatever we have covered, that will continue. Understood? Clear हो गया कि नहीं? So this system is not available now. The Supreme Court basically revives the earlier collegium system of judges appointing judges. Correct? By struck down NJC, Supreme Court revives the old system of collegium system of judges appointing the judges. Reason क्या था? Because वहां पे member में who was there? Law minister. Then फिर what is the use of it? Again it is a collegium system only then. हाँ, तो फिर बचा क्या है? Correct?
Not mentioned under any article.
Which one?
NJAC.
It is actually 99th amendment. It was actually. जो article number 124 it was changed, article number 217 it was changed, but abhi it was removed now. It is not a part of the constitution, so it is already struck down by the Supreme Court. So 99th amendment was struck down now. Clear है? कोई डाउट यहाँ तक? Done. So appointment clear. Oath of Supreme Court judge administered by President and oath of High Court judge administered by Chief Justice of India. अपने मन से. It is Governor. ठीक है? So Supreme Court judge oath is administered by the President or some other person appointed by him, or High Court judge oath is taken administered by Governor. Clear है? Next we are going to cover removal of the judges. So यहाँ पे we are going to remove this. It is same for Supreme Court as well as High Court judge removal. It is same. Basically, Supreme Court judge or High Court judge, they can be removed from his office by the President only. By President from their office. Correct? But President will do when? Only after an address passed in Parliament. जब Parliament एक address pass कर देगा कि yes we need to remove these judges, then only President is going to remove the judges of Supreme Court and High Court. Constitution में we are not having a procedure to remove Supreme Court judge and High Court. Then Parliament has passed a law, इसको बोलते हैं Judges. Correct? Inquiry Act 1968. It regulates the procedure for removal of Supreme Court judge and High Court judge. Correct? Judges Inquiry Act 1968. It provides the entire procedure. Procedure matlab this address, how to pass this address in Parliament. Clear this? Next is, first important thing is, what is the ground? जैसे हमने पढ़े थे ground for removal of president, vice president. So what is the ground for removal of vice president of India? No. And removal of president of India? Yes. Office of prophet. ये कहाँ से बना लेते हो? Yes. Yes, exactly. Violation of the constitution. ऑफिस ऑफ प्रॉफिट से कोई मतलब नहीं है, ठीक है, वो कंडीशन ऑफ सर्विसेज में आता है. सो इनके लिए भी कुछ ग्राउंड होने चाहिए. सो ग्राउंड्स आर टू ग्राउंड्स आर देयर. फर्स्ट इज प्रूव्ड मिसबिहेवियर, and second is incapacity. These two grounds are there for the removal of judges of Supreme Court as well as High Court. Done. Now grounds clear. Only in two grounds. Incapacity in the sense physically not able to perform the duties. Or for example, unsound mind, incapacity. Clear? Next is, process can start from the Lok Sabha also, and process can start from the Rajya Sabha also. But when you enter the motion, supported by 100 members, सेम अगर यहाँ पे एंटर हो रहा है, then it should be 50 members. If it is starting from the Rajya Sabha, then that motion need to be supported by 50 members. If it is starting from the Lok Sabha, then it should be 100 members. Then, like example, if no confidence motion you are introducing in the Lok Sabha, here also you need to take support of how many members? 50 members. Correct? If suppose example you are going to remove President of India, then नहीं, यहाँ पे motion support के लिए when you are introducing, at that time you need to take support signature 1/3 of, ऐसे कैसे चलेगा, खत्म. तो पॉलिटी या हिस्ट्री में कैसे याद रखोगे? इट इज वेरी इजी. 1/4 है ना, 1/4 होना चाहिए इन केस ऑफ लोकसभा. राज्यसभा में कितना होना चाहिए? 1/4. क्यों बढ़ाना है? 1/4 ओनली. रिवीजन इज मिसिंग. ठीक है, रिवाइज करना है. रिवाइज करने के लिए पढ़ना भी है. देन दिस, उसके बाद क्या होगा? व्हेन दिस, फॉर एग्जांपल, इट इज स्टार्टिंग फ्रॉम द लोकसभा ओनली नाउ. सो व्हेन इट स्टार्टिंग फ्रॉम द लोकसभा, then it is will go to the speaker. Correct? अगर वहां होगा then chairman. Speaker can reject also. Speaker can accept also. क्या होता है, रिजेक्ट कब करेगा, whenever there is no prima facie evidence is available regarding this ground. Incapacity of proved misbehavior, it is not available, so they are not able to provide this grounds. Prima facie evidence they are not able to provide, then the speaker can reject also. Suppose example speaker accepted this. Suppose example speaker has accepted. When a speaker is accepted, then what will happen? One commission will going to be set up. 3-member committee will going to be set up. 3-member committee. In 3-member committee में कौन members होंगे? One Chief Justice of India, another is Chief Justice of any High Court, and one any eminent jurist. 3 members होंगे, first, second and third member. Chief Justice of India, Chief Justice of High Court, Chief Justice of India, Chief Justice of High Court and eminent jurist. क्या? President only. Correct? Clear this? A jurist person, CGI and Chief Justice of India. अगर for example this removal process is for Chief Justice of India only, then यहाँ पे होगा retired Chief Justice of India. अगर जिंदा है कोई, correct? Then retired Chief Justice of India, then Chief Justice of High Court or jurist. Clear this? If removal process of CGI only is going on, then in place of CGI यहाँ पे होगा retired CGI. Then this committee will going to submit the report. This committee क्या करेगा? This committee will going to submit the report. Or this committee frame the charges. This committee frame the charges. इसमें वो guilty, not guilty. Correct? Not guilty, then process to stop here only. Correct? If it is guilty, then it is debate होगा आपका and vote. Correct? Voting, which majority is required? Special majority is required. Special means कौन सा वाला? 368 वाला, वही 2/3 of presented voting and absolute majority. After that it will go to the second house, like example here is Rajya Sabha. Correct? Rajya Sabha again क्या करेगा? Rajya Sabha will going to debate and then vote. Vote again किससे? Special majority. Special majority means article number 368. If it is passed, then it will go to the किसके पास आएगा? President for signature. Clear अभी? Done?
Sir, can the president deny it? And he did send back?
No. He need to sign it now. Done?
Again, Rajya Sabha denied that.
Rajya Sabha can, yes. If Rajya Sabha is not able to pass by this special majority, then also process stop here only. Correct? And all these things should be done in one session only. Correct? In one session. क्लियर हो गया अभी? एनी डाउट इन दिस प्रोसेस? अगर कोई डाउट आ रहा है आपके मन में, एंड दीज थिंग्स नीड टू बी डन इन वन सेशन ओनली, ध्यान रखना, not in 2 sessions. Like monsoon session is going on right now. If we need to remove, so we need to remove in this monsoon session only. We cannot wait then for the winter session. So till now no judge, कोई भी जज अब तक रिमूव नहीं हुआ इंडिया में. Okay, 2 times it was tried. Yeah, not guilty means the person has not done any crime, in the sense under this proved misbehavior or incapacity. यहीं पे the person those against whom these charges are going on, this person can defend himself. Done. So 2 times this thing was tried, but again it was not a successful. Once it was not successful because Congress government has not supported it later. So then that person became Chief Justice also of the one High Court, and one was basically a Calcutta High Court judge. He was removed from Supreme Lok Sabha also. He was removed from the Rajya Sabha also. Now the time was to sign it. Impeachment process or removal process has been passed. So now Pratibha Patil has not signed the removal of that judge because that judge before it only resigned. Correct? जब ये पूरा लोकसभा राज्यसभा ने पास कर दिया था, इन मिडनाइट इट वाज पास्ड बाय राज्यसभा. हम लोगों के सब कुछ मिडनाइट में ही हो रहा है आजकल, ठीक है. आजादी जो मिडनाइट को मिली थी. So राज्यसभा is passed this and in that night only it will go to the प्रतिभा पाटिल to sign it, but वो इतनी एक्टिव नहीं थी, लेजी थी. उतने में बिफोर ओनली दैट गाय हैज रिजाइंड. बट अगेन उनके पास फिर भी चांस था प्रतिभा पाटिल अगेन सी कैन, बिकॉज अल्टीमेटली व्हेन यू रिजाइन you will send resignation to whom? Chief President only. President is not accepting the resignation, so President can sign the removal only. But President has not done it. नहीं तो फिर जीके का बुक में लिख जाता who is the first judge who is removed. अच्छा नहीं लगता. Because of that reason is President has not accepted that and resignation was accepted by the President. Clear? Done? कोई डाउट अभी तक? Okay, so the president will not going to use veto power here. Simple reason is it is not a bill, it is not an, because it is just duly passed by the Lok Sabha as well as Rajya Sabha. यहाँ पे president का कोई veto का मतलब ही नहीं है. He need to sign it only. Correct? Any doubt till now? So this process is not mentioned in the constitution. ध्यान रखना. Process is mentioned under Judges Inquiry Act 1968 only.
Sir, after impeachment or resignation, can you see this law or
No, no. Because ultimately those person even retired, they cannot practice. और ये पर्सन तो बेसिकली रिमूव ही हुआ है ना. अब रेजिग्नेशन के बाद, क्योंकि रेजिग्नेशन के बाद तो कर ही सकता है बिकॉज दिस पर्सन इज नॉट गिल्टी. अब लेकिन करोगे क्या? बिकॉज आफ्टर रिटायरमेंट और आफ्टर दैट यू आर नॉट अलाउड टू practice the law in before the Supreme Court or High Court. Because ultimately, if any chief justice of India or judges after retirement they became a advocate, so it will not be fair because ultimately your colleagues are there only. समझ गए? So because of that they are not allowed. Any doubt till now? No. Now comes to acting chief justice. Acting Chief Justice of India. So acting Chief Justice of India will be appointed by President. President can appoint a judge of Supreme Court as an acting Chief Justice of India. Supreme President of India can appoint any judge of Supreme Court as the acting Chief Justice of India. क्यों करेगा? Because जो current Chief Justice of India होंगे, this person post is vacant. Correct? It may person post is vacant, or that person is temporarily absent. Correct? Or it may be possible that person is unable to perform the duties. Perform the क्या? हाँ हाँ, यस, जो एक्टिंग चीफ जस्टिस होगा दैट विल बी द जज ऑफ सुप्रीम कोर्ट. And that person shall be appointed by the President of India. The President can appoint a judge of the Supreme Court as an acting Chief Justice of India. Reason is this, because the current Chief Justice of India, that post is already vacant, or person is temporarily absent or unable to perform duties. Clear है? Done? कोई doubt? Now, sometimes क्या होता है कि we are not having the quorum in the Supreme Court, or we are not having sufficient number of judges in the Supreme Court. So during that time, we should have a sufficient number of judges के लिए we can hire ad hoc judges. We can hire ad hoc judges. Clear? We can hire the ad hoc judges. So these ad hoc judges जो होंगे, they will be hired by Chief Justice of India only. So Chief Justice of India can basically appoint any judge of High Court as a judge of Supreme Court as an ad hoc judge. Understood? So when there is a lack of quorum, or when there is a not permanent judges are not available, they are not able to hold this session, at that moment Chief Justice of India can appoint a judge of the High Court as an ad hoc judge of the Supreme Court, correct, for a temporary period, not permanent basis. For a temporary period, President can appoint a judge of the High Court as an ad hoc judge of the Supreme Court. But whenever he is going to do, then CGI need to take the previous consent of, yes, ad hoc judges क्या होता है? For example, you are having 33 judges plus one Chief Justice of India, but this 33 some vacancies are there. That means here only 10 judges are available right now. 23 are their vacancies, so they are not available. So now we need judges of the Supreme Court. We need to continue the sessions. So at that time, we can hire a judge of the High Courts as an ad hoc. This is at the level of Supreme Court. Correct? So who will do? CGI will do after taking previous consent of the President of India, plus after taking consultation with Chief Justice of concerned High Court. Done? यहाँ पे कंसेंट नहीं लिखना है, बट कंसल्टेशन इज मोर देन इनफ. यहाँ पे कंसेंट है रिगार्डिंग द प्रेसिडेंट. अल्टीमेटली यू आर अपॉइंटिंग एट द लेवल ऑफ सुप्रीम कोर्ट जज. So High Court judges promoted to the level of Supreme Court judge. Who appoint them? President. यहाँ पे who is going to do? CGI. So at least take consent from the President. And that judge जो यहाँ पे ad hoc judge होगा, it will be High Court judge only, correct? Pawan? This High Court judge definitely should have qualification to become Supreme Court judge. Understood? The person, the High Court judge, who is going to be appointed at the level of as ad hoc judges Supreme Court, this person should have a qualification to become judge of the Supreme Court. That means उस High Court judge के पास कितना experience होना चाहिए? How much? 10 years. कहाँ से हो गया? अभी भूल गए. 5 years. Correct? 5 years. कोई अगर Supreme High Court का 5 years judge है, that person can become Supreme Court judge. So this High Court judge should have at least experience of 5 years of as a High Court judge. Then अब सोचो एग्जाम्पल कि you are saying that यहाँ पे number of judges were not available, permanent judge, some vacancies were there, because of that you have taken the High Court judge. But if at the High Court level also same things are there, they are also not having sufficient number of judges, and still we need the judges. देन कहाँ पे जाना है हमको? मजिस्ट्रेट डिस्ट्रिक्ट वाले पे है? अरे एनी हाई कोर्ट में नहीं, उनके पास भी नहीं है, दे आर नॉट रेडी फॉर इट. देन रिटायर्ड जजेस, एग्जैक्टली, अपने पास साधन है अभी, रिटायर्ड जज, मरे नहीं है वो लोग, ठीक है. देन रिटायर्ड जजेस, retired judges, correct. So CGI can request a retired judge, again appoint नहीं है, क्या है? Request, इसलिए wording देख रहे हो, request आ गया, वहां पे appoint था, यहाँ पे request है. CGI can request a retired judge of Supreme Court. CGI can request a retired judge of Supreme Court or High Court with duly qualified. मतलब अगर हाई कोर्ट जज है, दैट पर्सन शुड हैव क्वालिफिकेशन आल्सो. अल्टीमेटली वी आर अपॉइंटिंग एट द लेवल ऑफ सुप्रीम कोर्ट, सो दैट हाई कोर्ट जज शुड हैव द क्वालिफिकेशन आल्सो. क्वालिफिकेशन कितना होना चाहिए? 5 years जज टू एक्ट एज ए हाँ ड्यूली क्वालिफाइड. दैट पर्सन शुड बी ड्यूली क्वालिफाइड. Act as a Supreme Court judge for a temporary period. Correct? So CGI can request a retired judge of Supreme Court or retired judge of High Court who is basically duly qualified for appointment of Supreme Court judge for temporary period के लिए only. Only for the temporary period. Correct? What is the salary should be there for this retired judge? That shall be decided by the president only. So salary or allowances shall be decided by the president. Clear this? Salary or allowances will be decided by the president only. Next is, but this person shall not be deemed as the judge of the Supreme Court. This person shall not be deemed as judge of Supreme Court. ये क्या मतलब है? Like retired High Court judge. Now he is actually appointed as a Supreme Court judge by CGI. Correct? For temporary period, he was working for 1 year 6 months. After that, he will go again. So now he will be called as judge of Supreme Court. No, he still will be called as judge of High Court only. ये नहीं कि नेम प्लेट में नाम चेंज कर लिया, कि पहले रिटायर्ड हाई कोर्ट जज था, फिर रिटायर्ड सुप्रीम कोर्ट जज. करेक्ट? ऐसा पॉसिबल नहीं है. सेम आफ्टर रिटायरमेंट ही कैन नॉट क्लेम द पेंशन एज ए रिटायर्ड सुप्रीम कोर्ट जज. ही विल कंटिन्यू द पेंशन एज ए हाई कोर्ट जज ओनली. क्लियर दिस? तो इसीलिए बोलते हैं अदरवाइज दैट पर्सन शैल नॉट बी डीम्ड एज जज ऑफ द सुप्रीम कोर्ट. दे आर जस्ट देयर टू डिक्रीज द वर्कलोड for temporary period. Done. So अभी फिर से ad hoc this shall be appointed by whom? President. Chief Justice of India. देखा, अभी से भरोसा उठ रहा है यूपीएससी का. ठीक है. So retired, okay, acting Chief Justice of India appointed by, acting Chief Justice of India shall be appointed by Chief Justice of India. So President of India, yes, after consultation with retired जज से करना है. ठीक है. अदर जजेस, ऐसा हमने कहीं पढ़ाया है? नो कंसल्टेशन इज रिक्वायर्ड. करेक्ट? Why need to consult with the CGI when CGI post is vacant? Correct? So no need to consult. Ad hoc judges shall be appointed by CGI after consultation with president. Correct? Consultation or consent? Consent with the president, correct? Consultation with the chief justice of High Court only. Done. So now comes to jurisdiction of Supreme Court. Jurisdiction of Supreme Court, correct? कई jurisdiction सुप्रीम कोर्ट के पास, like original jurisdiction, appellate jurisdiction, correct? Advisory, review, right? Then so कितना टाइप्स का जुरिस्डिक्शन? ओरिजिनल जुरिस्डिक्शन, जिसमें ओरिजिनली डायरेक्टली वी कैन अप्रोच टू सुप्रीम कोर्ट. ओरिजिनल मींस we should not go first to the high court and then to the supreme court. Original means directly we can approach to the supreme court only. Appellate means coming through appeal, high court ka appeal against appeal rule to the supreme court. Advisory, जो president of India takes advice. Review, judicial review. And writ basically can come directly under original also. Okay, under writ also we can approach direct to the supreme court. So original jurisdiction two types का होता है. एक है writ jurisdiction, ऑलरेडी writ पढ़े थे. हाउ मेनी writs आर देयर? 5. कौन सा 5 था? बस 3 ही हुआ. Yes, what is the difference between provision and certiorari? Okay, यही अंतर है पक्का. Okay, so certiorari is available against administrative decisions. Yes, it is available. 1993, correct? So writ already done. And other is federal dispute. Federal dispute क्या है? Union versus state, state versus state, union plus state one side, other state other side. Correct? It simply means union versus state, union plus state versus state, or state versus state. ये कोई भी इशू होगा that will be dealt only by the supreme. See, this जो केस होगा ये, this is exclusive also. Original as well as exclusive. This is not exclusive because writs we can file in high court also. So it is just original but not exclusive. But this is original as well as exclusive. These cases we cannot actually deal where? These cases we cannot deal in high court. They are always in supreme court. कौन सा डील? हाँ. If union and state they are on same page for one particular policy and other states are not in the same page, then next is appellate. So appellate can be in civil case, criminal case, and third is constitutional case, and fourth is SLP, special leave petition. इसको बोलते हैं स्पेशल लीव टू अपील, इसको बोलते हैं स्पेशल लीव, करेक्ट. SLP स्पेशल लीव पिटिशन और स्पेशल लीव टू अपील. Done. So civil case, if any big civil matter is there that is already dealt by the High Court, you can go against it in the Supreme Court if that important question of law is involved. Criminal case में क्या होता है कि when lower court has acquitted the person, correct? Lower court has acquitted the person, but High Court has taken the case, correct? And then provided the maximum punishment, that is 7 years or more, or capital punishment, for example. Then this case must be dealt with Supreme Court. This is compulsory. So lower court ने क्या कर दिया है, one accused को acquit कर दिया कि no case is there, but High Court has taken the case and High Court has given the capital punishment. Then this case must be taken before the Supreme Court. Constitutional case, if any important question of law is involved regarding the constitution interpretation, that also we can appeal in Supreme Court. And then special leave petition. ये special leave petition क्या होता है? Basically, special leave petition ये है कि whenever any High Court actually gives a decision, correct? Now, you are not happy with the decision or you want to actually file a case in the Supreme Court now again. So what will you do now? You will ask a certificate from the High Court. High Court will provide you a certificate. With that certificate, you can approach to the Supreme Court. Then Supreme Court is going to hear your matter. High Court will provide the certificate. Reason is this, because High Court will लगता है this there is very important question of law is involved. So better it must be dealt by the Supreme Court. But suppose example if High Court has not given you certificate, and still you want that this case must be dealt by the Supreme Court, then what will happen? You have to file this petition only, इसको बोलते हैं special leave to appeal. So this can be filed when already judgment has been given by the High Court, or if still judgment has not been given by the High Court. Correct? In between also you can file this special leave petition. So when you file this special leave petition before the Supreme Court is not going to accept that petitions. It is the discretionary power of the Supreme Court whether to accept or not. It is not your right. It is not your right. It is the discretionary power of the Supreme Court. The Supreme Court के ऊपर है whether Supreme Court is accepting it or not. इसी को बोलते हैं special leave petition. Correct? So this can be filed in which case? This can be filed in civil case also, in criminal case also, in constitutional case also, in tax law also. Any of the matter it can be filed special leave petition. Correct? ये आता है आपका अंडर आर्टिकल नंबर 136. वो अभी छोड़ दे, बाद में पढ़ते हैं. First we are going to cover this only. This already we have covered. This already we covered. Now original jurisdiction. Now exception to the original jurisdiction. Exception क्या है? Right? Exception to the original jurisdiction. Exception in original jurisdiction. What is this exception to the original jurisdiction? ये बेसिकली क्या है कि what are those cases that cannot be heard by the Supreme Court at all? Those exceptions. First is exception, any pre-constitutional treaty, agreement, any pre-constitutional treaty, agreement. So any dispute that is arising out of pre-constitutional treaty or agreement, these cases cannot be taken by the Supreme Court. मतलब कोई ऐसा agreement है, treaty है that has happened before 1949 only. Like 1923 में एक agreement हुआ. Now because of that dispute happened. So these cases cannot be taken by the Supreme Court. Second is interstate water dispute. Interstate water dispute, these cases also cannot be taken by the Supreme Court. उसके लिए already tribunal is there, interstate water tribunal. Third is matters related to Finance Commission. Matter related to the finance, इसका मतलब एक फाइनेंस कमीशन प्रोवाइड्स द रिकमेंडेशंस लाइक 14th फाइनेंस कमीशन रिकमेंडेशन में उन्होंने बोला कि 42% ऑफ द नेट प्रॉफिट शैल बी शेयर्ड विद द स्टेट. अब स्टेट गवर्नमेंट इज नॉट हैप्पी विद द रिकमेंडेशंस, so whether state government can file a petition before the Supreme Court regarding these recommendations of the finance commission? Answer is no. Reason is finance commission whatever the recommendation they give, they are advisory in nature. It is up to the government only whether to accept or not. Clear? Fourth is that matter cannot be taken by the Supreme Court is ordinary dispute of commercial in nature. Ordinary dispute commercial in nature. Ordinary dispute of commercial nature between center and state. Between union and state. Then इसका मतलब क्या? For example, one company PSU of the central government involved, one PSU of the state government is involved. So it is a commercial nature. It is nothing to do with the federal dispute, correct? So that can be dealt by the High Court also. So this is not having original jurisdiction in the Supreme Court. Clear this? So these are the cases जहाँ पे Supreme Court cannot take the case. Or any other treaty, for example, जहाँ पे specifically mention कर दिया गया है कि it is not in the jurisdiction of Supreme Court. In that treaty also cannot be dealt by the Supreme Court. Clear है? Any doubt till now? So these are the exceptions are there. देखो इसके लिए क्या है? प्री कंस्टिट्यूशन ट्रीटी सोल्यूशन तो होना चाहिए ना, because you have said that कि Supreme Court cannot hear this issue, then who will hear this issue? So इसके केस में कि Supreme Court only will give the judgment, but not judgment, but advice through advisory jurisdiction. इसके लिए क्या है? ट्रिब्यूनल है, करेक्ट? ये क्या है? बिकॉज इट इज ऑलरेडी एडवाइजरी इन नेचर ओनली, सो कोई इशू नहीं है. ये कैन बी डेल्ट बाय द हाई कोर्ट ऑल्सो. सिंपल सोल्यूशन यहाँ पे है. फर्स्ट इज एडवाइजरी जुरिसडिक्शन, अभी हम लोग कवर करेंगे. प्रेसिडेंट टेक एडवाइस अंडर आर्टिकल नंबर 143. Then any doubt? Clear? So now special leave petition. और अपील बाई स्पेशल लीव, इसको भी बोलते हैं अपील बाई स्पेशल लीव. आर्टिकल नंबर 136. So it is basically a petition seeking the special permission from the Supreme Court. It is nothing but special permission from Supreme Court to appeal against a judgment of high court और हाई कोर्ट एक्सप्रेसली मत लिखो, जजमेंट ऑफ इंफीरियर कोर्ट और लोअर कोर्ट, it can be high court also, it can be tribunal also. सिंपल मैं आपको बता दिया, जैसे कोई ट्रिब्यूनल है या हाई कोर्ट है, दे हैव गिवन द जजमेंट, you want to appeal against it in Supreme Court. These high court or tribunals, they will give you the certificate. With that certificate, you can file appeal against those judgment in Supreme Court. But what if they are not given the certificate, or case is still pending, no judgment came, but still you think that this case must be heard by the Supreme Court only, because यहाँ पे important question of law related to the constitution is involved. So now you are going to file this petition, appeal by special leave. So you are asking a special permission from the Supreme Court to take a case against the judgment given by the lower court. That can be tribunal also, that can be high court also, correct? And then it is up to the Supreme Court whether to accept or not. It is not your matter of right. It is the discretionary power of the Supreme Court. So लिख सकते हो, it is not a matter of right. It is the discretionary power of the Supreme Court. Yes, yes. हाँ. Yes, interstate will not come because उसके लिए already, for example, things are there. See, regarding interstate tribunals are there, their judgment is final actually. So that is also mentioned under Constitution only. ठीक है? After given by even lower court also. Correct? Done. So it is not a matter of right. It is a discretionary power of the Supreme Court whether to accept it or not. And this special leave petition is available in case of civil case also, criminal case also, constitutional case also, tax law also. Correct? The Supreme Court may accept it or Supreme Court can reject it also. Done? So basically SLP, it is not an appeal. इसको appeal नहीं बोलना है. ये होता है petition for an appeal. Okay? It is a prayer for an appeal. I am just requesting you take my appeal. It is not actually an appeal. Correct? It is just a request. समझ में आ गया कि नहीं ये वाला स्पेशल लीव पिटिशन? लक्ष्मीकांत में इज नॉट अवेलेबल इन बेटर वे, वहां पे डिफिकल्ट होगा आपको समझना ये स्पेशल लीव पिटिशन. नेक्स्ट इज रिव्यू पिटिशन. सो रिव्यू पिटिशन क्या होता है? फॉर एग्जांपल, whatever the decision Supreme Court will going to give, that can be reviewed by the Supreme Court again. Understood? That is review petition. So yes, which one? This review petition. Review is different actually. Appellate में only thing is appellate in civil case, criminal case, constitutional case, and then SLP. That is appeal. This is review. Because judgment already has been given by the Supreme Court. You want to review it. So review petition, the rules होते हैं, rules under article number 145. Under article number 145, Supreme Court of India has the power to review its judgment. Supreme Court of India has power to review its judgment. Correct? Supreme Court of India has power to review its own judgment. Because High Court ka to judgment can be reviewed by the Supreme Court. Who will review the Supreme Court judgment then? So that Supreme Court only will do. But only condition is this कि that review petition must be filed within 30 days of its judgment. The review petition जो आपने डाली है that must be filed before Supreme Court within 30 days of its judgment, of the judgment or order. Of its judgment. Clear? अब सोचो एग्जाम्पल आफ्टर रिव्यू पिटिशन ऑल्सो यू आर नॉट हैप्पी, राइट? तो उसके लिए वन मोर इज जिसको बोलते हैं क्यूरेटिव पिटिशन, दैट कॉल्ड इज just to avoid the miscarriage of justice. Supreme Court is the last resort of the justice. So because of that, if after review petition you are having a curative petition, this curative petition concept basically originated in 2002 only. This was originated in 2002 in case Mura versus Ashok Hurra case. In Rupa Ashok Hurra versus Ashok Hurra case, this concept of curative petition come into picture. Then this curative petition basically heard by top 3 judge of the Supreme Court. Top 3 judge basically कौन होगा? One Chief Justice of India plus 2 other judges who, sorry, CJI plus other 2 judges plus जो वो जज जिन्होंने रिव्यू पिटिशन डिसमिस कर दिया है. So ध्यान रखना, क्यूरेटिव पिटिशंस are always heard by top 3 judges including Chief Justice of India plus judges who dismiss the review petitions. Correct? ये आप हटा दो यहाँ से. Who dismiss the review petition. Curative petitions are heard by the top 3 judges including the Chief Justice of India plus judges who dismissed the review petition. क्या क्या? No. Top 3 judges are different, na. They also should be there because ultimately they have dismissed on what basis they have dismissed. You need to take opinion of them also. Yes. See, the top 3 judges are also there, so they are also going to say, see, if they have rejected review petition, जरूरी है कि वो गलत थे. It may possible they were correct. So that things will be checked by now top 3 judges together with them. If top 3 judges are not involved basically, then what will happen? Then ultimately again you have to hear entire cases entirely. Chief Justice of not aware about what is the cases. It is going to take lot of time then. Understood this or not? So curative petition always heard by the top 3 judges plus those judges who have dismissed the review petition. Then उनसे पूछना है ना on what basis you have dismissed it. They will tell this was the ground. If these grounds were correct, then CJI also will say yes, we need to dismiss this also. Correct? That is curative petition. So topmost only. Chief Justice to senior most judge.
Even Article 137.
That is what this. This is coming through article number 137 only. Complete justice. Correct? Done? Any doubt? Yes, it was Gopal, Ayodhya wala case maybe they have filed, correct. Lot of cases may they have done it. Even in one of the this Tamil Nadu case tha, जिसमें Rajiv Gandhi killers case. So all these cases में these were involved basically.
don't have a time limit like 30 days after this.
ऐसा टाइम नहीं दिया उन्होंने. Done. Next is advisory jurisdiction. इसके बाद भी आप खुश नहीं हो, still you are not happy, that means you are married then, correct? फिर आपको कोई खुश नहीं कर सकता है, ठीक है. Next is advisory jurisdiction. Three bench judges, 3 judges होते हैं. Yes. No, that is in even first time whenever you are going to file the case, वहाँ पे भी 3 bench judge can be possible. वो constitutional benches होता है basically, उनके लिए होता है, जहाँ पे at least 5 judges should be there, constitutional bench. Now comes to advisory jurisdiction. So this comes under article number 143. This is not available with USA Supreme Court. Even nowhere it is available. ये इंडिया ने ही एक ऐसा इन्वेंशन किया है, correct? To take the advice. So Constitution under article number 143 authorizes the president to take advice from Supreme Court. Again, governor cannot take the advice from the High Court. उनके लिए कोई ऐसा नहीं. It is only for this Supreme Court and President of India. Correct? 2 matters में only 2 matters. First matter is important question of law is involved. Important question of law or fact of public importance, ये इन्वॉल्व है आपका. सेकंड इज related to the dispute arising out of pre-constitutional treaty. एग्रीमेंट, ये 2 मैटर हैं. इन 2 मैटर्स में प्रेसिडेंट ऑफ इंडिया कैन टेक एडवाइस ऑफ द सुप्रीम कोर्ट. क्लियर? In these 2 matters, important question of law, public importance, correct, that is arisen or which is likely to arise, कुछ भी हो सकता है यहाँ पे, correct. Same any dispute that is related to the pre-constitutional treaty or agreement. ये हमने बताया था pre-constitutional treaty or agreement. Supreme Court is not having original jurisdiction, right? Added over here. In this case, first case, this first case, Supreme Court can deny also, not ready to give the advice. But in second case, it is compulsory for the Supreme Court to give the advice. So in first case, Supreme Court even can deny that I am not ready to give the advice. But in second case, it is compulsory over the Supreme Court to give the advice. Clear this? Done? So one more thing, whatever the advice that is given by the Supreme Court, this advice is not binding over the president. Whatever the advice that is given by the Supreme Court, it is not binding over the president. Advice given by the Supreme Court, it is not binding over the president. तो अभी हमने थर्ड जज केस देखा, थर्ड जज स्पेशल रेफरेंस केस, वो यही केस था, स्पेशल रेफरेंस केस रिगार्डिंग दिस. Important question of law was involved. करेक्ट, इसीलिए उसमें जो भी वेयर एवर यू जस्ट सी स्पेशल रेफरेंस केस, करेक्ट, तो समझ लो स्पेशल रेफरेंस केस मींस इट वाज दैट केस जहां पे प्रेसिडेंट ऑफ इंडिया हैज टेकन द एडवाइस ऑफ द सुप्रीम कोर्ट, देन दिस इज एडवाइजरी jurisdiction. Any doubt? The next is court of record. Supreme Court is also a court of record. Article number 129, court of record. इसका दो मीनिंग है. फर्स्ट मीनिंग इज दिस, whatever the judgment Supreme Court is giving, the judgment will be recorded for perpetual memory or testimony purpose. That means those judgment can be used as a reference in other cases. Understood? It simply means कि judgment or order of Supreme Court can be recorded. Correct? Can be recorded for perpetual memory. It simply means they can be used as reference in future cases. Correct? Like example, whenever any important case is there, तो जहां पे जो lawyer होता है, advocate होता है, that advocate tells the Supreme Court, sir आपने previous case में you have told this thing, so that is court of record. Correct? This is the first meaning. Second meaning of this record means Supreme Court can punish for the contempt of the court also. For contempt of the court. These two things together, they are considered as court of record. Understood? So court of record means whatever the Supreme Court gives the judgment will be recorded. The judgment will going to be taught in the universities, that is law universities. So these judgments will be used as a reference in the future cases by Supreme Court also and by other courts of India. Second is Supreme Court can punish for the contempt of the court also. All together is considered as court of record. So Supreme Court is also a court of record. High Court is also a court of record. क्योंकि हाई कोर्ट के भी जजमेंट होते थे, आर रिकॉर्डेड फॉर परपेचुअल मेमोरी, फॉर ए रेफरेंस. हाई कोर्ट आल्सो कैन पनिश फॉर द कंटेम्प्ट ऑफ द कोर्ट. Subordinate courts are not court of records. Subordinate courts are not court of record. समझ में आ रहा है? इसलिए आपने देखा सबऑर्डिनेट कोर्ट का कभी भी कोई रेफरेंस नहीं आता है ना, कि जबलपुर सबऑर्डिनेट कोर्ट ने कुछ ऐसा डिसीजन दिया है, हाई कोर्ट उसको सुन रहा है. नहीं, दे आर नॉट हैविंग कोर्ट ऑफ रिकॉर्ड. कंटेम्प्ट ऑफ द कोर्ट ऑलरेडी वी हैव कवर्ड. कहां पे पढ़े थे हम लोग? आर्टिकल 19 में पढ़े. कंटेम्प्ट ऑफ द कोर्ट, रीजनेबल रिस्ट्रिक्शंस. कंटेम्प्ट ऑफ द कोर्ट्स आर बेसिकली टू टाइप्स, सिविल कंटेम्प्ट एंड क्रिमिनल कंटेम्प्ट. व्हाट इज सिविल कंटेम्प्ट? When you are not obeying the order issued by the court, आप उसको implement नहीं कर रहे हो, that is civil. Criminal contempt, yes, when you are actually slandering the authority of this court, or you are disrupting them, you are taking something bad about them by writing, by oral or someone, that is known as criminal contempt. Criminal contempt में punishment can be possible maximum 6 months. Maximum कितना होगा? 6 month के लिए. Then contempt of the court के जो cases होते हैं, they can be filed only after taking permission of the attorney general in Supreme Court. High court में then advocate general. ऐसे कोई आप जाके कोर्ट में मतलब नहीं लिख सकते. Either Supreme Court is going to take the case in suo motu basis, or we need to take the opinion of the Attorney General. Yes. There is the disciplinary committees are there, but whenever the court cases are there, these cases can be filed only after taking permission of the Attorney General, or Supreme Court can take on its own also, suo motu. जैसे for example अदर नहीं है कि you just go and file a police complaint, that is not available. ठीक है, that is contempt of the court. समझ में आ रहा है ये? Now next is, so it was done court of record also. Now subordinate courts are not court of record. आप लिख लो, subordinate courts are not the court of record. It is only Supreme Court and High Court. Both are court of record. Next is judicial review. Correct. So recently current affair में Delhi service bill that is passed by the parliament, that is ordinance. So everyone understood about it? No. No. Yes. Oh, इतना. So बाकी को समझ में आ गया? बाकी ने देखा नहीं, जिन्होंने देखा तो लैंग्वेज बैरियर हो गया. ठीक है. So just 5 minutes में I will explain you. 5 minutes only. दिल्ली सर्विस बिल, करेक्ट. अब आपको डेली आपको न्यूज नहीं पढ़ना है, बॉल बाय बॉल कमेंट्री. ओके, one day only we are going to cover Delhi service bill. See, this is a union territory, correct? Union territory is there. आपको पता है there is a union list is there and concurrent list and state list is there, correct? This जैसे other states, normal other states are there. Normal other states they can make the law on concurrent list. They can make law on state list also. Same union territory also can make law on concurrent list, and union territory also can make law on state list. Clear this? But Delhi is a special case basically. Special case ये है दिल्ली में कि yes they can make the law on concurrent list, yes they can make law on state list also, but in this state list there are few subjects are there. Subject number 1 that is known as public order, subject number 2 that is police, and subject number 18 that is land. In these three matters में they are not allowed to make the law. जो दिल्ली यूटी का जो असेंबली है they are not having any authority to make the law on these three subjects. Rest of the cases में they can make the law. So they can make the law on concurrent list also. अब रही parliament. When in the context of other states, parliament can make law for union also. Parliament can make the law on concurrent also, but parliament cannot make law on state list. Normal situation I am telling you, correct? Okay, but in case of UT, Delhi, parliament can make the law on union list also. Parliament can make the law on concurrent list also, and parliament can make the law on state list also. So in state list, parliament also can make the law, and UT assembly also can make the law. This thing is mentioned under article number 239 capital AA, because this basically was inserted for the union territory Delhi only. इसी में one article number is there, that's article number 239 AA, clause 3 and sub clause B. That sub clause B में they have mentioned this only, कि yes, union territory Delhi assembly has complete authority to make the law on state list except these three. Still they cannot stop parliament to make the law on state list. So parliament is still able to make the law on state list, correct है? इशू क्या था बेसिकली इनका? इसी में अंडर आर्टिकल नंबर 239 AA they have mentioned this thing that LG is there, LG versus CM, correct? LG and CM. जैसे other state में there shall be a council of ministers headed by the chief minister to advise the governor. Same यहाँ पे भी है कि there shall be a council of ministers headed by the CM to advise the LG, and LG will function according to that advice only in those cases जहाँ पे LG को लगता है कि they need to use the discretionary power, except in those areas where LG think that we need to work in the discretionary power में. So which are those areas जहाँ पे LG think that? So this also will be decided by the LG only. Correct? समझ में आ रहा है कि LG will work according to advice given by the Council of Minister, except in that area where LG think that LG need to work according to his own discretionary power. So who will decide that discretionary power? LG only will decide discretionary power. It was also clear. क्या हुआ मैटर्स? ऑलरेडी पुलिस गया, पब्लिक ऑर्डर गया एंड 18 लैंड गया. अभी क्या हुआ कि इन 2016 में केस केम टू दिल्ली हाई कोर्ट. दिल्ली हाई कोर्ट एंड केस वाज रिलेटेड टू द सर्विसेज. स्टेट सिविल सर्विसेज. इसमें ऑफिसर्स इंक्लूडेड होंगे कौन से? ग्रुप ए ऑफिसर सिविल सर्विस प्लस जो आप आईएएस सेलेक्ट होते हो, whenever you choose this cadre, then the next cadre will be given to you, except IPS, because IPS already excluded from the police. They are already under control of union only. Then Delhi High Court says that this state civil service, it comes under central government only. It comes under central government. अभी क्या होगा कि now Delhi CM will not be happy here. Now he will going to file a case in the Supreme Court. Then Supreme Court provides one verdict in 2018, and that verdict was a split verdict basically. Split means two judges were there. One was saying yes, it comes under Supreme Court, sorry, central government. One was saying it comes under state. So solution तो नहीं मिला हमको. Then next is 2023 में one judgment again came on 11th of May. Supreme Court has given the judgment. Supreme Court says that at Delhi we are having a parliamentary democracy. Correct? And this parliamentary democracy mein we should have a triple chain accountability. Triple chain accountability. What is this triple chain accountability? First is this: civil servants, they are accountable to ministers. Correct? Second chain is ministers are accountable to legislature. And third is legislature, they are accountable to electorate. That means voters. ये जो तीन चैन हो गया, फर्स्ट चैन, सेकंड चैन एंड थर्ड चैन. So every parliamentary democracy is having this triple chain accountability. When you are saying that civil servants are not coming under minister, that is state ministers, then how you can take this minister's accountability to the legislature? So ultimately when you break this first chain, then all the chains will going to be broken. Otherwise, see, these guys are not doing proper work. For that work, why you are making ministers accountable? When ministers are not accountable to the legislature, then why you are making legislature accountable to the electorates? Simply because of that reason, state civil service should come under the state government only. Clear this? So this judgment was in favor of the Delhi government, that is Arvind Kejriwal. Against this judgment only, central government has passed an ordinance. Central government has passed an ordinance. Correct? In that ordinance, they have passed Delhi Service Bill. सेंट्रल गवर्नमेंट उनका एक लॉ है GNCTD एक्ट 1993, इसी को अमेंड कर दिया. गवर्नमेंट ऑफ नेशनल कैपिटल टेरिटरी ऑफ दिल्ली एक्ट 1993, इट वाज अमेंडेड. एंड यहां पे व्हाट दे हैव डन इट, दे हैव क्रिएटेड ए न्यू अथॉरिटी. दैट अथॉरिटी इज नोन एज नेशनल कैपिटल सिविल सर्विस अथॉरिटी. So एक पैनल बना दिया. क्या पैनल? नेम इज नेशनल कैपिटल सिविल सर्विस अथॉरिटी. एंड दिस पैनल इज कंसिस्ट ऑफ दिल्ली CM, he is a chairperson. Second is Home Secretary, and third is Chief Secretary. Both are representing the union, and this will be from the state. Now this authority will going to advise to whom? LG. Regarding what? Transferring of the officials, posting of the officials, disciplinary actions we need to take, that everything will be given by the LG through advice given by CM, Home Secretary, and correct. अब this advice will be through majority only. मेजोरिटी में कौन हो गया? मेजोरिटी में ये दोनों आपस में जुड़ गए, यूनियन गवर्नमेंट से हैं. So now even CM wants to give that advice. If these two guys are not happy, then these two guys is going to, okay, completely send the adverse opinion to the CM, and they can send advice to the LG. For a moment, these two guys are also with CM only. For a moment, and they send advice. It is not binding over LG. Even though that advice given by this committee to the LG still can take a sole discretion. Understood or not? So LG can reject the advice also. So ultimately, who is super CM now? LG is the super CM. Correct? So LG is deciding regarding transfer, then this P for posting, D for disciplinary actions. That is what has been done under Delhi Service Bill. One more. Yes? LG can be considered that they can send. See, whenever that is for that purpose, whenever Council of Minister send the advice to the LG, and LG को लगता है कि we need not to follow that advice, then LG can send that advice to the president, correct? And then whatever the decision president is going to take, LG will going to take that advice. यहाँ पे वो चीज है ही नहीं, correct? Because this is not a council of minister. This is only for the state civil service. That's it. This is civil service board is there for every other state. Same way, this is for this Union Territory National Capital Civil Service Authority, consists of CM and Home Secretary and Chief Secretary, and given to the LG. LG can take the sole discretionary power here. Next case क्या था इसमें? See, we have seen this thing. For example, state list. Under state list, we are having list number 1, list number 2, list number 18. Public order, police, and land. They already taken away from the Union Territory. This is list number 41. This is about state civil services and state public service commission. Ultimately, we have taken away this from the Union Territory. Then Kejriwal actually contention was this only. Ki how we are able to take away this list number 41 from us without amendment of the constitution. You have taken away through ordinance only. And ordinance you cannot amend it. Because in that article number 239AA, you have mentioned only 1, 2 and 18, not 41. But through this ordinance, you have taken away 41 completely from us. So you have amended the constitution. So recently the petition that is filed before the Supreme Court is checking this only. Whether through ordinance you can take away this 41 or not. Correct? Through ordinance you can amend the constitution or not. So everyone is aware, through ordinance you cannot amend the constitution. Central government says that it is not an amendment of the constitution. We are just using article number 239 capital A, 3 and B. यहाँ पे लिखा है कि we can make law on any subject. That is what we have made. We have not amended the constitution. The constitution article is still written same as it is. Just we have made the law. Clear अभी? ये problem चल रहा था. And there is various boards are there, various commissions are there. The chairperson of these boards and commissions also will be appointed by now LG. Like Delhi Jal Board, Delhi Women Commissions, all these chairperson will be appointed by LG. Done?
So LG is more powerful than CM.
Yes. See, this is not the case of Delhi basically. Okay. This is not the case of Delhi. If you check any other capital city of any country, all capital city they are under control of central government only. Delhi is not the case. Like example, if you take Washington DC, Washington DC is a federal district. It doesn't come under any state there, even though that is a federal country. But still, Washington DC comes. It is in a federal district, and in Washington DC also there is a mayor is there, council is there. That mayor can make a decision, council can make the law. But still, that law or decision made by the mayor or council, they can be override by the USA Congress. USA Congress क्या हो गया? USA Parliament. So even though they have this power to make the law, but whatever the law they are going to make, USA Parliament still can override. Same तो यहाँ पे वही हुआ ना, correct? If you take the example of Australia also, Canberra, 6 states are there. Canberra उसको भी बोलते हैं ACT, जैसे अपने बोलते हैं National Capital Territory, they call that ACT, Australia Capital Territory. यहाँ पे भी they are having mayor and council. Whatever the decision or law made by the council, that can be overridden by their parliament. And their governor general, that is our president, their governor general can override any decision taken by that mayor and council. No, even though you take the example of Paris, you take the example of London, they're also not supreme. They all are under central government. Reason is this: in capital city, you are having lot of federal office. Just take an example: if this police is given to Delhi government, correct, and there is federal office like Supreme Court is there, Parliament is there, various councillors are there, foreign officers are there, everyone is there, correct. If this police went to Kejriwal, for example, and he start misusing it, then entire central government will be under control of Kejriwal only or not? This is the reason it was not given to the state government. Clear? Yes, yes. Yeah, that is every state, but Delhi is not a state. That is the thing is, Delhi is not a state. Why it is unfair to Delhi? That is, Delhi is a capital city. It cannot be given to any one particular state. So Delhi always will be under control of central only. See, it is, see why Puducherry has no issue then. See, CM is, see, earlier CM was not there even. This came in 1993. Correct, because they think that we also should have some local representation over there. So there are other subjects are there, you have to work in other areas. Correct. So that purpose CM is there. That's it. If they want, they can remove entire CM also. They can remove entire Union Territory. Sorry, this assembly also. Because before 1993, we were not having CM. This came only after 1991 when 239 AA was added. No, main reason was vigilance officers basically. Because whenever actually this Kejriwal, see, when Sheila Jishit was the CM, at that time there was no problem between center and state. When Sheila Jishit was CM, actually at that time, at the central BJP government was there different color, then also there was no problem. She was always able to work. Why this problem happened after 2014? Because you are dreaming of a power that is given to other states, and you want to enjoy that in Union Territory. That is the problem. If you want to enjoy a power of full-fledged state, you have to go to the full-fledged state only. Like, see, right now Punjab Aam Aadmi Party is there. Any problem is happening between central and no, because आपके police आए, you are having police, आपको land चाहिए, land is there, but this is UT, this is capital city, this cannot be given to anyone, because parliament is there, federal offices are there, CBI office is there, everyone is there, correct? So you cannot misuse that power then. Yes, ordinance. The ordinance is parliament will pass it. Parliament can make the law. So, okay, definitely. So when parliament was not in session and then this ordinance is passed, now ordinance has been approved also. अभी approve हुआ ना लोक सभा and राज्य सभा में. So it is an act only. It is passed from the Lok Sabha also. It is passed from the Rajya Sabha also.
Sir, so ordinance can become a law.
हाँ, definitely. पढ़े तो थे हम लोग ये. पढ़े नहीं थे? Within 6 weeks, if it is approved by the parliament again, then it will start working as a normal law only. Clear? Any doubt here? कोई doubt? Okay, now come back again. So, judicial review. Problem is regarding state civil service. Regarding is because see, in any other state like CM and Council of Ministers are there, they are behaving with civil servants in proper way, correct? But in Delhi case, there is a problem happening continuously. Reason I don't know क्या हो सकता है personal या क्या है because this Delhi CM was also IRS. He was having a group एक अपने अंदर नहीं होता है कि हम कभी IAS नहीं बन पाए. Now I will control them somehow, correct? तो एक वो जीलस वाला चीज चल रहा है. नहीं तो अदर स्टेट में तो कोई इशू नहीं है ना. Everyone is working fine. अब सी वही स्टेट सिविल सर्विस इन पंजाब रीजन इज भगवंत मान. भगवंत मान को कोई इशू नहीं होगा कि आप आईएएस बने, क्योंकि मेरा सपना ही नहीं था कभी आईएएस बनने का, करेक्ट? This is also can be one of the reason is in Delhi mein for because Delhi was because see Delhi was never actually complete free state. It was always under control of the central, and it is not Delhi only. I will tell you now. You just take the example of any capital city of the world. All are under control of the central only. Correct? Now comes to judicial review. बट आपको पता होना है फैक्ट, बस आपको दिल नहीं लगाना है इसमें कि आप सीएम के तरफ हो या पीएम के तरफ, आपको फर्क भी नहीं पड़ेगा. जब आप खुद स्टेट सिविल सर्विस में जाओगे, यू विल बी पार्ट ऑफ द अनेक्स, देन आई होप यू विल बी इन द साइड ऑफ मोटा भाई ओनली. अमित शाह कैन प्रोटेक्ट यू, करेक्ट? बिकॉज लास्ट 2-3 days का जो डिबेट हुआ था, यू पीपल मस्ट हैव सीन दैट डिबेट. इट वाज वेरी फैंटास्टिक एक्चुअली. लॉट ऑफ फैक्ट्स यू विल कम टू नो अबाउट फ्रॉम दिस डिबेट्स. तब आपको पता चलेगा रियल में पॉलिटिशियन के पास कितना नॉलेज है. ये कई आईएएस ऑफिसर्स हैं, दे आर जस्ट 1/10 ऑफ दैट नॉलेज. लाइक अमित साहब को आप क्या समझते हो? ही इज नो नॉलेज. ही हैज मोर नॉलेज देन इवन कैबिनेट सेक्रेटरी, करेक्ट? बिकॉज ही इज हैविंग पॉलिटिकल नॉलेज आल्सो. पॉलिटिकली कंट्रोल करना इज वेरी डिफिकल्ट. एडमिनिस्ट्रेटिव तो कोई भी कर सकता है ना लॉ से, अंडरस्टूड? सो लास्ट जैसे यस्टरडे का जो डिबेट था रिगार्डिंग अदर बिल्स का था, वो दैट वाज वेरी फैंटास्टिक स्पीच. आपको जब भी टाइम मिले, इंस्टेड ऑफ वाचिंग अदर इंस्टाग्राम रील्स, वॉच दैट डिबेट एक्चुअली. ठीक है? नाउ जुडिशियल रिव्यू. चलो आप इंस्टाग्राम रील में फालतू में खर्च मत करो टाइम अपना. Now judicial review. So judicial review basically coming from 3 important article number 13, article number 30 to article number 2 to 6. So judicial review as a term, it is not mentioned in our constitution. Judicial review as a term, it is not mentioned in our constitution. It is basically flowing from this article number 13, article number 32 and article number 2 to 6. क्लियर है? तो एक चीज पता चले, जुडिशियल रिव्यू इज नॉट this is not present in our constitution. Article number 13 क्या था? Any law that is inconsistent with the fundamental rights shall be considered as null and void. So वहां से क्या पावर है? जुडिशियल रिव्यू. 32 रिट पिटिशंस के लिए कॉन्स्टिट्यूशनल रेमेडीज फॉर सुप्रीम कोर्ट. 2 to 6 हाई कोर्ट के लिए जो रिट पिटिशन कॉन्स्टिट्यूशनल रेमेडी गिवन टू द हाई कोर्ट ओनली. जुडिशियल रिव्यू में दे आर गोइंग टू रिव्यू, किसका किसका रिव्यू करेंगे वो लोग? दे कैन रिव्यू ऑफ लॉ enacted by parliament, enacted by state legislature, assembly or council, or executive branch. Executive branch both union as well as state. What is judicial review? This question was asked in UPSC prelims also earlier. Okay, this judicial review का meaning क्या है? What is the meaning of judicial review? They have given 4 options A, B, C, D. Option A was correct. Correct. Option A में simply they have mentioned review of law passed by the legislature and order issued by the executive. So judicial review में it is not about just review of the law. Review of the, because law की definition क्या थी वहां पे? आर्टिकल नंबर 13 में लॉ, ऑर्डर और ऑर्डिनेंस और rules, regulations, notifications, everything will be reviewed under judicial review. Clear? Judicial review as a principle, it is not bad. But यही judicial review after some time can become judicial activism. ये भी बुरा नहीं है, ये भी अच्छा है. Judicial activism. Judicial activism अभी हम लोग पढ़ेंगे later. This all these things principles. Judicial activism क्या है? कि when one of the organ of the state they are not working properly, that a space or vacuum will be created. In that vacuum, judiciary will enter. That is judicial activism. यही बाद में बन जाएगा आपका judicial overreach. Judicial overreach is unconstitutional basically because it violates the principle of separation of power. Correct? Overreach. Like example, Keswananda Bharti case, the doctrine of basic structure, it comes under judicial activism. Correct? Like one of the Rajya Sabha member of parliament, Ranjan Gagoi, okay, there, he was also claiming in that debate that this basic structure doctrine is a debatable principle. We need to debate about it, whether it is correct or not. Clear this? So that is comes under this judicial overreach means when judiciary is like deciding this thing. Ban the vehicle that is already 15 years old, 10 years old, who need to stand, for example, in for national anthem and all this. These are areas when they decide. It is basically judicial overreach. That is policy decision of the central executive only. Like example, central government need to auction coal. On what basis they need to auction coal? It is a complete prerogative of the executive only. But यहाँ पे who is deciding? For example, Supreme Court बोलते हैं कि it should be first come first basis only. So we are entering into the domain of the executive that you cannot do. For example, when this judiciary start making the law also, judiciary start making the law also. So you are making the law. Ultimately, you are entering into the territory of parliament. So you are again violating the principle of separation of power. It is also judicial overreach. But problem with this judicial overreach is what looks judicial overreach to me. For you, it will be judicial activism. Simple. इसलिए there is a very thin line between judicial activism and judicial overreach. If judiciary gives a decision in my favor, I will call it judicial activism. If it is against you, you will call it judicial overreach. Done? Okay, so that's it. Next class में हम लोग again going to cover judicial activism, overreach and review and comparison about them. This is the main topic only, not the prelims topic. After that, your Supreme Court and High Court done. High Court में आपको कुछ नहीं पढ़ना है because removal same है, appointment already we have covered, appeal लगभग same है, correct? So Supreme Court we have covered, that is more than enough. Done? Two 26. Regarding the
Regarding the subordinate posts to be under the
That is subordinate courts, so directly comes under High Court only. Yes. That is not judicial review. Then, so subordinate court is still left, appointment of district judge and all this. That require not more than 30 minutes. We will cover that also. Okay, thank you.